Get ready guys for dictation at the speed of 120 plus. Start. Coming to the facts of the present case, it cannot be said that the defense taken by the defendant is totally sham stop. There are certain circumstances which may prima facie raise some doubts about the credibility of plaintiff's version and led some credence to the defense taken by the defendant that the checks in question were without consideration stop. Although, as per the plaintiff, four checks were presented to the banker and each time they were dishonored, not a single letter was written by the plaintiff to the defendant about the return of these checks as unpaid stop. Further, learned counsel for the plaintiff made candid admission to the effect that no notice was served on the defendant before filing the present suit stop. Why plaintiff would not write a single letter or serve notice upon the defendant for payment of the alleged outstanding amount before filing the suit is baffling to the mind stop. Now let us examine this aspect further. Is the contest of the submission made by the defendant stop. It is not explained by the defendant oblique plaintiff as to on what account these payments were received stop. Thus the defendant has raised good defense and triable issue indicating that he has fair and bona fide defense stop. Para. Moreover, this court in the case of Suri and Suri Private Limited held that when the suit is filed on the basis of several dishonored checks not presented at all for encashment relief claimed would be outside the scope of Order 37 of CPC and would not be maintainable stop. The plaintiff will have to dealt with an ordinary way stop. No doubt there may be some justification in the stand taken by the plaintiff, but for filing the suit under Order 37 to the Code of Civil Procedure, it was still necessary for the plaintiff to present the remaining checks to the bank stop. Admittedly, 7 out of 11 checks given to the defendant were not presented for payment stop. Therefore, the suit under Order 37 would not be maintainable stop. It is settled rule of law that wherever the defense put forth by the applicant defendant is bona fide and raises tribal issues, the applicant defendant would be entitled to leave to defend stop. This rule vests pervasive judicial discretion in the court to grant, refuse, or grant conditional leave to defend the suit by the defendant stop. This discretion, of course, has to be exercised in accordance with settled principle of law stop. There is dual purpose sought to be served under the specific provisions of Order 37 of the Code stop. One is to provide expeditious disposal of the claim by adopting recourse to summary procedure, while the other is to provide a safeguard to the interest of the plaintiff stop. In other words, if the court is satisfied with the claim of the plaintiff and the fact that the defendant has only sham or moonshine defense, the court may refuse to grant leave to defend and pass the decree forthwith stop. But in other cases, the court may grant leave with or without conditions stop. Para. The court strikes a balance between the case of the plaintiff and the defense raised by the defendant stop. The propositions laid by the Supreme Court in its various decisions may be summed up as follows stop. If the defendant satisfies the court that he has a good defense to the claim on merits or raises a tribal issue, the defendant is entitled to an unconditional leave stop. And if the defendant discloses such facts as may be deemed sufficient to entitle him to defend, the court may impose conditions as to time of trial or mode of trial stop. Para. Challenge in these appeals is to the judgment rendered by the learned single judge of Bombay High Court in writ petition number 2500 of 2004. Stop. The writ petition filed by the appellants was dismissed by the learned single judge while holding that the trial court was right in its view that there was no scope for granting extension of time beyond the period of 90 days to file the written statement. Stop. Factual background needs to be noted in brief. Stop. Para. In a suit for partition, separate possession and perpetual injunction filed by respondent number 1, the appellants were arraigned as defendant numbers 15 and 1. Stop. They sought time to file the written statement and the trial court granted time till 17th November 2003. Stop. On that date, another application was filed for extension of time to file the written statement. Stop. Time was allowed till 19th February 2004. Stop. As it was holiday on that day, the written statement was filed only on 20th February 2004. Stop. Trial court refused to accept the written statement on the ground that the written statement was filed beyond the period of 90 days. Stop. The appellants filed this writ petition before the Bombay High Court. Stop. By the impugned order, the High Court dismissed the writ petitions. Stop. The logic as appears from the orders passed by the trial court and the High Court is that there was no scope for granting time to file written statement beyond the prescribed period of 90 days. Stop. Learned counsel for the appellants submits the view taken by the High Court was clearly untenable. Stop. Learned counsel appearing for the respondents spotted the order passed by the trial court and the High Court. Stop. Para. Order 7 Rule 1 after the amendment casts an obligation on the defendant to file the written statement within 30 days from the date of service of summons on him and within the extended time filing within 90 days. Stop. The provision does not deal with the power of the court and also does not specifically take away the power of the court to take the written statement on record though filed beyond the time as provided for. Stop. Substituted Order 7 Rule 1 intends to curb the mischief of scrupulous defendants adopting dilatory tactics, delaying the disposal of cases, causing inconvenience to the plaintiffs and petitioners approaching the court for quick relief, and also to the serious inconvenience of the court faced with frequent prayers for adjournments. Stop. The object is to expedite the hearing and not to scuttle the same. Stop. While justice delayed may amount to justice denied, justice hurried may in some cases amount to justice buried. Stop. Anxiety of Parliament is to secure an expeditious disposal of civil suits and proceedings without sacrificing the fairness of trial and principles of natural justice. Stop. Para. The point of consideration is whether the provision providing for maximum period of 90 days is mandatory and the court is altogether powerless to extend the time even in exceptionally hard case. Stop. It is also to be noted that through the power of the court under the proviso appended to Rule 1 of Order 7 is circumscribed by the words shall not be later than 90 days, but the consequences flowing from non-extension of time are not specifically provided through they may be read by necessary implication. Stop. Merely because a provision of law is caused in an active language implying mandatory character, the same is not without exception. Stop. The courts, when cancelled upon to interrupt the nature of the provision, may keeping in view the entire context in which the provision came to be enacted, hold the same to the dictionary though worded to in the negative form. Stop. Thanks all of you. Now go for typing.